Tens of thousands of people condemning the Supreme Court's decision to overturn a landmark ruling on abortion rights. President Joe Biden has called it a sad day for the country, while states have already begun rolling out new draconian rules that will shape the lives of millions of people.
A landmark ruling with repercussions for generations. Abortion rights law Roe v Wade overturned after nearly 50 years, sparking protests and celebrations. From the steps of the Supreme Court to the streets of New York City, Los Angeles and Dallas. We don't care, people die! Thousands voicing their anger. In the nation's capital, demonstrators burned a symbol of democracy and freedom, driving people to violence, a truck ploughing through pro-choice protesters in Iowa.
It's a sad day for the court and for the country.
President Joe Biden slamming the court for taking America back 150 years.
Let's be very clear. The health and life of women in this nation are now at risk.
The ruling gives states the power to decide their own laws, with half the country, 26 states, expected to ban or severely restrict abortions. 13 of those will move to do so within the next 30 days, while 6 states ceased abortions today, effective immediately. Arkansas was one of the first to change the law and one of half a dozen states that make no exemptions for rape or incest.
I can't wait for other women across Arkansas to have that same joy of seeing their child's face that maybe they would not have seen.
We did it!
Pro-life campaigners taking to the streets to celebrate.
I've been fighting my whole adult life, 4 decades, for this day. And it's one day, one victory. It's like taking Normandy Beach.
Republicans hailing a long-fought win.
Americans celebrate this historic victory because we know it will save the lives of millions of children and it will give families hope.
And applauding Donald Trump for appointing 3 Conservative justices to stack the nation's highest court. The former president today taking credit for what he called the biggest win for life in a generation. And his Conservative court appointments, it was my great honour to do so.
6 extremists on the United States Supreme Court have decided that they can force all of America to bend to their personal religious and moral views.
Women are going to control their bodies no matter how they try and stop us. The hell with the Supreme Court.
It makes me worried about the future of my kids and generations down the line.
For American women, their reproductive rights now come down to geography, but also class and race. Statistics show that those most affected by restrictive abortion laws are poor and women of colour. At this Mississippi abortion clinic, the care they once provided will now be a criminal offence.
These women in here right this moment are murdering their babies by the Constitution.
Healthcare centres across red states forced to turn people away.
I had a couple of staff members in here when the decision came in, and we could have took a moment to be together.
20 Democratic states will protect abortion rights.
Because in California, we refuse to turn back the clock and let radical ideologies exert control over your body.
A decision denounced around the world.
I've got to tell you, I think it's a big step backwards.
An attack on women's freedom, and quite frankly, it's an attack on everyone's freedoms and rights.
Restricting access to abortion does not prevent people from seeking abortion. It only makes it more deadly.
For all the condemnation and protests, not even the president has the power to rewrite history.
This is not over.
The moment America and women's rights went back in time. 50 years after legalising abortion, the Supreme Court reversing a constitutional right for the first time. It is a decision which defines the deep divides in American life. For some, cause for celebration.
So happy! That's a blessing, it's a miracle from God.
For others, a deeply personal betrayal.
I've had an abortion. I'll speak about that openly. I was 19 years old. I still sit with the grief of that. I sit with the shame of that. It's very nuanced. It doesn't mean if we make that choice, it doesn't mean we're happy about it. But at least we had the opportunity. I didn't have the funding to take care of a child the way I wanted to. I didn't have the opportunities that a lot of these people have to take care of their kids.
More than half of America's 50 states will severely restrict or ban abortion in the coming hours and days. It is a seismic shift which moved angry lawmakers to march through the Capitol.
This is part of the Republican Party's dark vision for America. They want to roll back every possible right that has been earned over the decades. It is an anti-woman agenda. The Supreme Court has lost its legitimacy.
Trying to tell women what to do with their bodies, that is absolutely ridiculous. Our choice.
We're not going back. We're not going to be treated as second-class citizens, and we're dang on sure not going to be treated as property.
An intervention too from the President, a practising Catholic who has wrestled with his feelings on abortion in the past, this time unequivocal.
It's a sad day for the court and for the country. Now, with Roe gone, let's be very clear. The health and life of women in this nation are now at risk.
5 of these 9 Supreme Court justices voted to overturn Roe versus Wade, a 1973 ruling which legalised abortion to the point of fetal viability. In his opinion, Justice Samuel Alito wrote, Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. Another judge said the court should reconsider rulings that now protect contraception and same-sex marriage.
Do you worry about same-sex marriage? There was a line.
Absolutely. I absolutely do. I absolutely do worry about same-sex marriage. I worry about the policing of all sex acts in general.
For people outside America, this feels quite dystopian.
It is dystopian. It is dystopian.
The Supreme Court hasn't arrived at this point by accident. Its newly conservative composition is the product of political manoeuvring. This decision, the result of decades of campaigning by old and young.
Today is the day we usher in a new era for the United States that protects life, that protects the unborn, that supports women.
This is undeniably a new era for America, but others will argue it's a repressive and regressive move, the full force of which will be felt by women in cities and states far from here.
The Supreme Court has overturned Roe v. Wade, the 1973 decision that established a constitutional right to an abortion in the U.S. Now, decisions on the legality of abortion are left to the states.
This is going to mean that access to abortion will vary dramatically depending on where you live.
While 16 states and the District of Columbia have laws that protect the right to an abortion, 22 states have laws that could ban all or most abortions now that Roe has been reversed, according to the Guttmacher Institute, a policy group that supports abortion rights and tracks national abortion statistics. The organization details a patchwork of laws among these states, including pre-Roe bans, trigger laws, and post-Roe restrictions that will determine the fate of abortion access in the U.S. 9 states have bans on their books that predate Roe v. Wade, which have been unenforceable for the past 5 decades.
Some of them date back to the late 1800s or early 1900s. These could be laws that could be enforced after this decision or as a result of this decision.
States like Arkansas can now revive their pre-Roe bans through official enforcement or by filing court actions. However, not all states with pre-Roe bans are poised to enforce the laws. Michigan Governor Gretchen Whitmer and abortion rights groups have filed lawsuits to block the state's 1931 law that makes providing an abortion at any point during pregnancy a felony. A Michigan judge, through a preliminary injunction, said the state can't enforce it.
Whereas others in states like Arizona, for example, I know lawmakers there are anticipating that they could enforce their own pre-Roe ban on abortion.
13 states have passed so-called trigger laws on the condition they would go into effect if the Supreme Court rescinded the constitutional right to abortion.
However, each of these laws are quite different from the other one.
And they can take effect at different times. In Kentucky, Louisiana, and South Dakota, the laws are enforceable immediately. But in Texas, Idaho, and Tennessee, there's a 30-day buffer period between Roe's reversal and when the laws go into effect. In some states, trigger laws can only be implemented after state government officials, such as attorneys general or governors, certify the high court's decision. Some states, including Georgia and Alabama, have sought to set stricter limits on when abortions can be performed during a pregnancy. Georgia's ban on abortion around when cardiac activity can be detected, and Alabama's near-total ban have previously been blocked in court because they conflicted with limits set by Roe.
Now the elimination of these federal protections for the procedure and the reversal of the Supreme Court precedent means that it's possible they can be resurrected in some way.
Some states don't have these specific restrictions or protections for abortion currently on the books, and it remains to be seen what actions they will take in the future. Meanwhile, abortion clinics in more liberal states have been preparing for an influx of patients.
They are expanding their hours, adding more staff, adding more days that they are available to accommodate what they expect to be even more patients coming in.
It has been nearly 1 year since the state of Texas enacted one of the strictest abortion laws in the country. It banned abortions as early as 6 weeks and empowered private citizens from even outside of the state of Texas to sue abortion providers or anyone who helps a woman obtain an abortion. And that law has had massive ripple effects. There are now women waiting 2 or even 3 weeks for abortion appointments in 8 states surrounding Texas. A new study found 45% of Texans who traveled out of state for abortions once that law was passed made their way to Oklahoma's 4 clinics. And then, as the Washington Post reports, Oklahoma lawmakers started passing a flurry of anti-abortion legislation in reaction to the surge of Texas patients. In fact, lawmakers in Oklahoma just gave final approval to a bill modeled after the Texas ban, prohibiting abortions after about 6 weeks of pregnancy when cardiac activity can be detected. Oklahoma's Republican Governor Kevin Stitt is expected to sign the bill into law within days. And if you're thinking, hey, wait, didn't Governor Stitt just sign a bill that would make performing an abortion a felony in Oklahoma, punishable by up to 10 years in prison? Well, the answer is yes. Yes, he did about 2 weeks ago. But that measure, it isn't going into effect until late this summer, and it's likely going to face big legal challenges. But the new bill that just got passed this week, it has an emergency provision in it, so it takes effect as soon as Governor Stitt signs it. So it's important to note, as we see a growing number of states passing anti-abortion legislation, a majority of Americans, though, remain supportive of reproductive freedoms. Take a look at this poll from Pew Research. 62% of women and 56% of men think abortion should remain legal. And let's not forget the backdrop here. All of these laws are being passed as we await the highly anticipated Supreme Court decision on abortion expected in just a few months this summer.
Nearly all abortion is on track to become illegal in Oklahoma after the state legislature there passed a bill to outlaw abortion after the moment of fertilization, except in cases of rape, incest, or the life of the mother. Here with me now is the governor of Arkansas, Republican Asa Hutchinson. Thank you for joining me this morning. We talked about Oklahoma a lot this week, got a lot of attention for banning abortion, as I said, starting at fertilization. But, Governor, in 2019, you signed a law in Arkansas that would do the same if Roe v. Wade is overturned. And your law only has exceptions for the life of the mother. So just want to be clear. If Roe v. Wade is overturned, no woman, unless her life is at risk, will be able to get an abortion in Arkansas?
If Roe versus Wade is reversed, then the trigger law in Arkansas would come into effect. And whenever I signed that law, I did express that I support also the exceptions of rape and incest. So the life of the mother and rape and incest are 2 exceptions that I believe should have been added that did not have the support in the General Assembly. And so we have to wait and see what the Supreme Court actually does. But if that Roe versus Wade is reversed, then what we've fought for 40 years and returning the authority back to the states will actually happen. You'll see states making different decisions based upon the values and the consensus of the people of that state. In Arkansas, we actually passed a constitutional amendment supporting the life of the unborn and recognizing that. And so the will of the people of Arkansas has been expressed.
Governor, you did sign the law that does not include any exceptions for rape and incest. I know you said that you would rather that not be part of the law, but it is, and you signed it. So I want to discuss the real world implications of this. For example, why should an 11 or a 12-year-old girl who's impregnated by her father or her uncle or another family member be forced to carry that child to term?
I agree with you. I've had to deal with that particular circumstance even as governor. And while it's still life in the womb, life of the unborn, the conception was under criminal circumstances, either incest or rape. And so those are two exceptions I have recognized, I believe are very appropriate. And what will happen as time goes on, if Roe versus Wade is reversed, these are going to become very real circumstances. I think the debate and discussion will continue, and that very well could be revisited.
But Governor, what if it can't be? I mean, you wanted the legislature in Arkansas to put those exceptions in. They didn't. Your term is almost up. What makes you think you can change it? And if you can't, that means that people who are still girls who are still children, 11 and 12-year-olds, might be in this situation in a very real way in just a couple of months, potentially.
Well, those are heartbreaking circumstances, and that's where in the last few years when we passed these trigger laws, we're expressing a belief. We're trying to return that authority to the states and to reduce abortions. But whenever you see real life circumstances like that, that debate is going to continue. And the will of the people may or may not change. But it's going to come back to the state's flexibility on that. I believe that those exceptions are going to be important in overall to save lives, because the public understands those exceptions, the importance of it. So I think that will be revisited. There's no guarantee of that, but the public opinion does matter whenever you come to your elected representatives.
Separate from those exceptions, I want to ask broadly about the responsibility of men here. Right now, a woman or a girl who has an unplanned pregnancy, if she wants to get support from the man who impregnated her, she has to seek him out, prove paternity, and then convince a judge to rule in her favor. And that all can take years, and it puts the burden on the mother. Are you going to change the system in Arkansas to hold men equally responsible for the children they're bringing into the world?
They should be held equally responsible, both in terms of paternity responsibilities, child support. Absolutely, that should happen. And if we can speed up the system to be able to accomplish that, then absolutely we should do that. And we talked about the difficult circumstances. The state does have a responsibility to help in terms of maternal health care, in terms of the child, and maybe in these circumstances making sure that there's the assistance that's needed. So we need to have wraparound services if there is those unexpected pregnancies that are traumatic or challenging.
He was asked about the Texas abortion bill and why force a rape or incest victim survivor to carry a pregnancy to term. This is how he responded. I want to play this for our viewers.
Why force a rape or incest victim to carry a pregnancy to term?
It doesn't require that at all, because obviously it provides at least 6 weeks for a person to be able to get an abortion. And so for one, it doesn't provide that. That said, however, let's make something very clear. Rape is a crime, and Texas will work tirelessly to make sure that we eliminate all rapists from the streets of Texas by aggressively going out and arresting them and prosecuting them and getting them off the streets. So goal number one in the state of Texas is to eliminate rape so that no woman, no person will be a victim of rape.
I'm wondering what you thought when you heard that.
Well, I find Governor Abbott's comments disgusting, and I think there's twofold. One, I don't know if he is familiar with a menstruating person's body. In fact, I do know that he's not familiar with a woman, with a female or menstruating person's body, because if he did, he would know that you don't have 6 weeks. Is that quote unquote 6 weeks? And I'm sorry we have to break it down on, break down biology 101 on national television, but in case no one has informed him before in his life, 6 weeks pregnant means 2 weeks late for your period. And 2 weeks late on your period for any person with a menstrual cycle can happen if you're stressed, if your diet changes, or for really no reason at all. So you don't have 6 weeks. That's first things first. The second area of this, when he talks about going after rapists and this language of him that he uses about getting rapists off the streets, the majority of people who are raped and who are sexually assaulted are assaulted by someone that they know. And these aren't just predators that are walking around the streets at night. They are people's uncles, they are teachers, they are family friends. And when something like that happens, it takes a very long time, first of all, for any victim to come forward. And second of all, when a victim comes forward, they don't necessarily want to bring their case into the carceral system. They don't want to re-traumatize themselves by going to court. They don't necessarily all want to report a family friend to a police precinct, let alone in the immediate aftermath of the trauma of a sexual assault. And so while some victims do use that recourse, and that is something that is completely available, and if that is part of their process, that's great. But this idea that we're going to, quote unquote, end rape when the same type of, frankly, rape culture and the same type of misogynistic culture that informed this abortion law to begin with is also, those beliefs are held by the governor himself and this Texas state legislature. Frankly, there are many people in power, as we know from the Me Too movement, that commit sexual assault, that help their friends cover up these crimes. And some of them even serve in the same state legislatures that are voting on these these anti-choice bills. It's awful. And he speaks from such a place of deep ignorance and it's not just ignorance, it's ignorance that is hurting people across this country.
You said rape culture and misogynistic culture are behind this Texas bill to begin with. Could you just explain that, to how you feel about that to people?
Sure. So when we talk about the law that was passed in Texas, we know that anti-choice bills are not about being pro-life. Because if they were about being pro-life, then the Republican Party would support, frankly, an agenda that helps guaranteed health care, that helps ensure that people who do give birth that don't have the resources to care for a child can have that care for a child. So we know that none of this is about life. None of this is about supporting life. What this is about is controlling women's bodies and controlling people who are not cisgender men. This is about making sure that someone like me as a woman or any menstruating person in this country cannot make decisions over their own body. And people like Governor Abbott and Mitch McConnell want to have more control over a woman's body than that woman or that person has over themselves. And what that shares what that shares with rape culture is that sexual assault is about the abuse of power, and sexual assault is about asserting control over another person. And the ease with which these men seek to do that to other people is atrocious. It is morally reprehensible, and they cannot even begin to understand the agonizing decisions that people have to make, including in cases of miscarriage, rape, and incest.
A dozen Republican-led states have moved to ban nearly all abortions since late June, when the U.S. Supreme Court overturned Roe v. Wade, which had legalized abortion nationwide since 1973, almost 50 years ago. More states are expected to enact more bans soon. As these laws take effect, shocking cases are surfacing, such as the 10-year-old Ohio girl who became pregnant after she was raped, had to travel to Indiana to get abortion care because she was 3 days past Ohio's 6-week limit, which doesn't include exceptions for rape or incest. At first, anti-abortion legislators and the Ohio Attorney General denied any of it was true. Then, when a man was arrested who admitted to raping the 10-year-old at least twice, they moved on to attack the OBGYN who had helped her get an abortion. Indiana's Republican Attorney General, Todd Rokita, said he was investigating whether or not the provider reported the rape to the state. Turns out she had, in fact, done so in accordance with state law, and she wrote a letter to him, a cease and desist letter, so he stopped threatening her for the moment. Abortion access workers say the new state-level anti-abortion laws threaten the ability of abortion providers to assist child rape and incest survivors. Prism reporter Tina Vasquez said such services are commonly sought, tweeting, "This morning I interviewed a person who does abortion access work in the Midwest. I asked about the story of the 10-year-old rape victim in Ohio who had to travel to Indiana for abortion care. The worker said they've helped 2 11-year-olds access care this week," she said. Meanwhile, a colleague of Indiana Dr. Caitlin Bernard, who assisted the 10-year-old in getting an abortion, wrote an op-ed in the New York Times about threats Dr. Bernard has since faced. Dr. Tracy Wilkinson, an assistant professor of pediatrics at Indiana University School of Medicine, wrote, quote, "The attacks on her were instantaneous and fierce. Multiple state attorneys general and high-profile conservatives suggested Dr. Bernard was a liar. Pundits questioned her integrity, and articles in numerous news outlets cast doubt on the story, with Wall Street Journal editorial board declaring it's a fanciful tale that was too good to confirm." Dr. Wilkinson continued, "This moment, post-Roe v. Wade, feels particularly frightening and is chilling to anyone who cares for patients, especially anyone providing reproductive health care. This saga has had real-world repercussions for Dr. Bernard. The local police have been alerted to concerns for her physical safety," unquote. This comes as House lawmakers voted mostly along party lines to pass 2 abortion bills Friday, including one that would safeguard the right to travel across state lines to get an abortion. This is California Democrat Judy Chu.
Make no mistake, if Republicans had their way, this would be a country of forced birth. They've already openly discussed a national abortion ban. When asked about that pregnant 10-year-old, the anti-abortion lawyer said that this child would one day see the benefit of being forced to carry her rapist baby. Can you imagine? They think it's okay that the 10-year-old is raped as long as she produces a baby. That's why we need to pass the Women's Health Protection Act, because every person, no matter what the circumstances, no matter how they become pregnant, deserves dignity, safety, and care in seeking an abortion.
Over many months, it was an impending ruling that had rattled a nation.
Women deserve better! Roe v. Wade has got to go!
It stirred division, anger, emotion.
Murder is not a right! You don't have a right to murder people!
And there is now a group of people for whom this judgment will have the most profound, most painful impact.
For them to be making these decisions right now is just simply unbelievable to me.
Trish Mitchell is a survivor of rape.
When I discovered I was pregnant, I was overcome with fear. I didn't know if I could provide the love, the nurturing, care, and support to a child that was a result of rape. I wasn't sure I was capable of that at that age. I was only 22 when this took place, and I didn't come at that decision lightly. It was a very difficult decision to make, but in the end, it was the best that was for me and my family.
Abortion was her choice, one that she could legally make, her constitutional right now taken away. And if you thought that there will be exemptions for rape, for incest, well, think again, because in 11 of the 50 states across this land, it doesn't matter if your pregnancy was the consequence of a sexual assault. State laws are set to require that you give birth to that child.
I considered taking my own life at that time. I considered not dealing with it at all, simply because I didn't have the tools to deal with it. I wish they understood the trauma that comes along with being sexually assaulted. I wish they understood how vulnerable you feel and how you feel like you have no decision, no choice in any of the situation.
3 million women in America are known to have experienced rape-related pregnancy in their lifetime. The true figure will of course be higher. Many choose not to report such awful experiences. But over many months following this debate, we found the ideology which drives the anti-abortion movement is deep.
And if the woman has been raped or a victim of incest,
We should kill the rapist, not the baby. The baby didn't have any part in it.
The fear now is that this will precipitate a public health crisis, with the most vulnerable now the most in need.
I think about how many women we might have to step over on a bathroom floor because they've made the decision to try and terminate their pregnancies themselves, or how many women don't have the means to travel to another state where abortion laws are different in order to have the proper care and the proper treatment for terminating a pregnancy. It's pretty scary.
What do we want? Abortion rights!
Right or wrong, this judgment represents a fundamental shift for women and for choice across this land. Part of America's social fabric has just been unwoven.
The court has done what it has never done before, expressly take away a constitutional right that is so fundamental to so many Americans that had already been recognized. The court's decision to do so will have real and immediate consequences. State laws banning abortion are automatically taking effect today, jeopardizing the health of millions of women, some without exceptions. So extreme that women could be punished for protecting their health. So extreme that women and girls who are forced to bear their rapist's child, with the child a consequence. It just stuns me.
You write that an 11-year-old girl there was allegedly raped. She is now pregnant, and under a new abortion law there, victims will not have the option of terminating a pregnancy. What more can you tell us about this law?
So in Ohio, they recently passed, like we were just saying, a heartbeat bill. So that means once a fetal heartbeat is detected, a woman no longer has a choice of whether or not to have an abortion. Now that happens about 5 or 6 weeks into a pregnancy, which of course, as you know, that is before most women even know that they're pregnant. So in this case, an 11-year-old girl obviously doesn't know she's pregnant 5 weeks into her pregnancy after being raped. She would no longer have a choice whether or not to carry that pregnancy to term if this law were enacted. Now, there are 4,000 women who are raped every year in Ohio. About 800 of those are products of incest. So people like these in the future would be the ones that wouldn't have abortion as an option in the future.
And have other states enacted similar laws like Ohio's?
There have been very few states that have actually not included that rape and incest exception. It's considered to be just kind of one step beyond the line. Except, of course, in the case of Alabama. Now, as you saw last week, that was a huge point of contention, and there was a shouting match that erupted on the floor over that amendment, and they ultimately stripped it from the bill. So, as it stands, Alabama's abortion ban does not include an amendment for rape and incest.
And that's the big difference here between what we're seeing in Alabama versus these other states.
Exactly. That and the idea that it's just all abortions. They're not even couching it with the fetal heartbeat.
Thank you. Ms. Foster, you think a 10-year-old would choose to carry?
In the 10-year-old case, first of all, the Ohio...
No, my question is, would a 10-year-old choose to carry a baby?
In the Ohio case, the Ohio Attorney General said that abortion would have been justified.
Focus on the question, please. Would a 10-year-old choose to carry a baby?
I cannot.
Do you think a 10-year-old should choose to carry a baby?
I believe it would probably impact her life, and so therefore it would fall under any exception and would not be an abortion.
Wait. It would not be an abortion if a 10-year-old with her parents made the decision not to have a baby that was the result of a rape?
If a 10-year-old became pregnant as a result of rape and it was threatening her life, then that's not an abortion. So it would not fall under any abortion restriction in our nation.
Ms. Warbelow, are you familiar with disinformation?
Yes, I am.
Did you just hear some disinformation?
Yes, I heard some very significant disinformation.
Why don't you tell me about that?
Yes, an abortion is a procedure. It's a medical procedure that individuals undergo for a wide range of circumstances, including because they have been sexually assaulted, raped in the case of the 10-year-old. It doesn't matter whether or not there is a statutory exemption. It is still a medical procedure that is understood to be an abortion. Beyond that, I think it's also important to note that there is no exception for the life or the health of the mother in the Ohio law. That's why that 10-year-old had to cross state lines in order to receive an abortion.
You know those people who are always like, but that is different, for every argument that mostly tries to shed light on female privilege? We get the feeling that there could be so many of such people in this video's comments, and so, we kick off with them. Rape has so many definitions nowadays, but at its core, rape is defined as a type of sexual assault usually involving sexual intercourse or other forms of sexual penetration carried out against a person without their consent. The key word in all rape discussions is consent, or someone voluntarily agreeing to a proposal. While we say that men and women are equal today, or at least societies are moving towards that, the traditional presentation of men as sexually active and women as passive has really shaped discussions surrounding consent. Sex being perceived as something men do to women as opposed to something men do with women has guided the persistent presentation of consent as exclusively female, in that men are the only ones who make the proposals in the context of sex, and as such, consent is something women give. So much so that a proposal coming from a woman is automatically accompanied by consent because the man's consent is irrelevant. All this based on the stereotype that men are always down for sex, and as such, consent in the context of men is not a thing. Rape may be as a result of using physical force, abusing authority, or engaging in sexual activity with against an individual incapable of giving valid consent, including one who is unconscious, incapacitated, lacks the intellectual capacity, or is below the age of consent. Of special interest for the But That Is Different Brigade would be the attempt to separate rape using force and rape resulting from invalid consent tied to an individual being below the age of consent, that is, statutory rape. Statutory rape is often defined as non-forcible sexual activity with an individual who is below the age of giving valid consent. Basically, statutory rape laws focus on protecting minors who cannot make informed sex-related decisions from predatory adults. The But That's Different Brigade would want to separate forcible and non-forcible rape, especially in an attempt to classify victims as true and technical victims of rape. This separation would only be fronted when we want to talk about male victims to reduce the seriousness of the crimes perpetrated against them. We could end this introduction here by arguing that rape is rape, but they would not just let it go that easy, so would take an extra step, as insurance. When it comes to male victims of rape, they always seek to separate true and technical victims, which is those whose rape was a result of force and those who were below the age of consent respectively. When it comes to female victims in the whole rape and sexual assault discussions, everything is bundled together to get the sensation feminism so widely craves. Here's an example. UN Women has widened the meaning of sexual assault to include staring and rank it up there as some of the ways in which women are sexually assaulted. This study published by the American CDC is commonly cited as the source of the 1 in 5 women are or will be victims of rape and sexual assault in their lifetime that has drawn a lot of hysteria, fear, and anger surrounding the topic. Part of what is defined as rape or sexual assault and included in the statistic is being worn down by a partner who constantly says they are unhappy just to get laid, you know, just like how women wear their partner down when they want a ring by being nagging and giving ultimatums in the name of an ultimatum. Things like these reduce the seriousness of rape by making sexual assault and related acts increasingly ambiguous in definition in the name of creating awareness while promoting the war against men. The war on men in this case arises from the use of sexual assault and rape laws as part of women's sexual selection arsenal by giving them a way to punish men for shooting their shot to wrong people. Essentially placing the power of deciding what sexual assault is and is not squarely on the woman, legally enforcing her decision, and accepting that definitions will differ from one woman to the next. The point in this video is determining what is perceived as fair, or not, when it comes to parenting resulting from criminal activity, which is why we merge anything related to rape, irrespective of the cause or the origins of the act. Some of the arguments presented by the judges in the highlighted cases are sure as hell only applicable to male victims because they would never say the same to female victims. That being said, let's do this. On the 16th of March 2004, the Courts of Appeals of Michigan, in deciding LME and Family Independence Agency VARS, ruled that a boy, who was sexually victimized by an adult woman when he was aged 14, cannot opt out of parenting and was liable for child support. In the case, the petitioner, who was the mother and referred to as LME, was 6 years older, born in 1968, than the respondent, born in 1974, who was the father and referred to as ARS. LME gave birth to BME while she was still married to DLE, whom she listed as the father, of course because she was the husband. LME and DLE stayed married for another 11 years after BME was born, and after the divorce in 2000, it was then determined that ARS was the father to BME. LME petitioned the court for a paternity test and a child support order against ARS, who objected on the grounds that BME was an outcome of sexual victimization perpetuated by an adult woman on a minor child, 14 years at the time, and that is below the age of sexual consent per Michigan statutes. In other words, the child was an outcome of a crime on a minor, and as such, should be exempted from fatherhood because awarding the order would effectively imply that LME would benefit from her crime with the victim paying the price for being a victim. In 2001, a New York court entered a filiation order suggesting that ARS appeared with counsel and admitted to being BME's father. The court declared ARS to be the father but did not order child support based on the respondent's submission to the jurisdiction of Michigan for the entry of an order of support. The Macomb County prosecutor petitioned the trial court on behalf of the petitioners. The respondent objected the child support filing, arguing that the child was an outcome of a sexual assault crime perpetrated by the child's mother. BME was conceived and born when LME was married to DLE. He had no knowledge of BME's existence until the case started, and LME should not benefit from her crimes in the name of child support. The trial court argued that BME was born out of wedlock within the provisions of the Paternity Act. The court did not find any grounds in the Family Support Act that would entitle LME to any relief. The trial court, in applying equitable principles, ruled that ARS was not responsible for child support. However, LME appealed. The petitioner argued that the trial court violated her equal protection rights and those of the child by failing to enter the child support order on the basis that the child was born out of wedlock and was a product of criminal sexual conduct. The petitioner argued that laws surrounding child support and any relevant protections do not differentiate the circumstances surrounding the birth of the child. The court argued that the petitioner's equal protection was not violated but the child's was. The appellate court held that the trial court erred in ruling that ARS was not liable for child support because ARS alleged sexual victimization was not reported and LME was never formally charged with the crime. Since she was never formally charged, then it doesn't count as a crime. However, the court argued that LME could still have been charged with at least third-degree criminal sexual conduct per Michigan statutes, even though the criminal conviction would not have any bearing on ARS' civil responsibility towards the child. You do know about victims of sexual victimization who come out years after the act happened and get justice. It is increasingly becoming clear that that only applies to women because if men do not report immediately, then no crime was committed. The Court of Appeals of Michigan held that ARS was only technically a victim of sexual victimization and the records reflected his willing participation in intercourse with LME, which resulted in the birth of BME. A technical victim, they said. A minor willingly participated in intercourse with an adult. Have that at the back of your mind. The court further argued that LME would not benefit from the child support order but BME would because the public policy of the state is to secure support for children, and as such, the award of child support even if conception was as a result of sexual victimization by the mother on the father is important public policy. But when states want to secure the lives of unborn children, you know how some people feel about that. The respondent's argument that he was a minor when she induced him to sex that led to the conception of the child confused two legal components. Because of his age at the time that the child was conceived, the law prohibits the adult in the relationship to claim consent as a defense. People v. Gengels found that proof of consent is no defense, for a female child under the statutory age is legally incapable of consenting. Therefore, even if ARS was a willing participant in sexual activity, LME could have still been charged with at least third-degree sexual misconduct. However, the issue focused on in the case was not criminal culpability or the victim's consent, but whether the victim was liable for child support. The argument in the case, based on Macomb Department of Social Services v. Westerman, Evink v. Evink, and Peller v. Peller, was that child support is not imposed to penalize or victimize either parent. The purpose of child support is to provide for the needs of the child. Child support is not imposed for the benefit of the custodial parent, but rather to satisfy the present needs of the child. Interestingly, the payment of child support reduces poverty for the custodial parent, which is mostly the mother, while it increases poverty for the non-custodial parent, which is mostly the father. This study finds that the relationship between child support and poverty is strongest in America, a country whose prisons house 50,000 fathers on any given day for child support arrears. Child support does not seek to benefit the custodial parent at the expense of the non-custodial parent while women are out here literally stealing men's sperm, a violation of their privacy, based on their earning capacities and filing for child support and they're getting it. But of course, child support is for the child. The court ultimately sought guidance from other states that have unanimously concluded that a child resulting from criminal sexual conduct does not absolve the father from their civil responsibility towards the child. In the California Court of Appeals case of County of San Luis Obispo v. Nathaniel J., a 34-year-old woman was involved in sexual activity with a 15-year-old boy and a child was born. Nathaniel argued that California's public policy protects him from sexual exploitation as a minor and hence he should be protected from the consequences of sexual victimization. Nathaniel further cited California law, all persons who suffer losses as a result of criminal activities shall have the right to restitution from the persons convicted of the crimes for losses they suffer. The court shut down the criminality of conception argument, with the argument suggesting that victims should not be responsible for supporting a child whose conception is an outcome of sexual misconduct by one of the parents. The court found that Nathaniel was a willing participant in sexual activity as opposed to being an innocent victim because he agreed to having engaged in intercourse at least 5 times, despite the fact that the mother was convicted of unlawful sexual intercourse with a minor. The court argued that victims who willingly participate in the crime are not really victims and are therefore not entitled to equal protection as actual victims, whatever that means. The court stated, quote, "One who is injured as a result of criminal conduct in which he willingly participated is not a typical crime victim." The court agreed that California's public policy protects minors from sexual exploitation, but it was willing to set that aside. Imagine an underage girl being labeled not an actual victim because she engaged in sexual activity with an adult male several times. How many men would be out of prison right now? In Hermesman v. Sayre, the Kansas Supreme Court sided with the State Department of Social and Rehabilitative Services that sought to compel Shane Sayre, who was 13 years old at the time that the child was conceived, to reimburse the money the state had paid for him for his child's support. Colleen Hermesman was Shane's babysitter when she was 16 and he was 12 years old around 1987-88. They engaged in a consensual relationship that resulted in Hermesman giving birth to Melanie, their daughter. The two had intercourse multiple times a week over a period of several months. A consensual relationship with a minor who is incapable of giving consent since the age of consent for sexual activity in Kansas is 16 years old. When Melanie was born, Hermesman was 17 while Sayre was 13. In 1991, Shawnee County's district attorney filed a petition seeking to adjudicate Colleen Hermesman as a juvenile sex offender for engaging in sexual activity with a minor under 16 years to whom she was not married, in violation of Kansas law. Hermesman was charged with statutory rape, but a plea bargain saw the charges reduced to contributing to a child's misconduct. Social and Rehabilitation Services filed a petition on behalf of Hermesman alleging that Sayre was her child's father and that the office had provided services to Hermesman under the Aid to Families with Dependent Children program. The petition sought to order Sayre to reimburse the financial assistance offered to Hermesman and their child. The district judge ordered that Sayre was the father and owed child support, arguing, quote, "It's my view in this case that the hearing officer's ruling," which essentially is that a minor may be held legally liable to provide reimbursement to the state of Kansas, is a correct ruling of law and that the issues of consent in the criminal case and so forth are not really relevant in a paternity proceeding, which we're talking about, civil liability to support a child. And so I would enter a judgment for all of the SRS reimbursement against Colleen Hermesman and Shane Sayre jointly and severally for the $6,000 plus. Sayre's consent in the presence of a child saw him order to pay support to a tune of $50 a month. Sayre appealed the judgment and the case was transferred to the courts of appeals. In the appeal, Sayre argued, "Can a minor, who is a victim of the crime of indecent liberties with a child, be responsible for any children conceived of the criminal union? Is it sound public policy for a court to order child support when the order creates a clash of one minor's right to protection from being the victim of a crime with another minor's right to parental support? Can a judgment ordering joint and several liabilities for child support be an adequate remedy when it fails to account for the wrongdoing of plaintiff appellee Hermesman?" The arguments were based on 3 premises. 1. Sayre was a minor, and as such, is incapable of consenting to sex. 2. Inability to consent should translate to not being liable for support. 3. Because he was not held liable for childbirth, he should not be responsible for child support. What was listed as statutory rape is now statutory crime of indecent liberties with a child, which reads, "Indecent liberties with a child is engaging in sexual intercourse with a child who is under 16 years. The administrative hearing officer and the district court argued that Sayre's consent was irrelevant in the case because when it gets to men and children are involved, their anything, in this case being privacy and consent, is completely irrelevant. The SRS, a government agency, maintained that Sayre was not a victim of statutory rape, pointing out that Hermesman stipulated to a lesser crime of contributing to child misconduct. The established facts in the case, without any reasonable doubt, suggest that her Mesman's charge does not change the fact that she engaged in sexual activity with a minor. The Kansas court ruled that under common and statutory law, Sayer was obligated to pay child support. Kansas Parentage Act states, if a man alleged or presumed to be the father is a minor, the court shall cause notice of the pendency of the proceedings and copies of the pleadings on file to be served upon the parents or guardian of the minor and shall appoint guardian ad litem who shall be an attorney to represent the minor in the proceedings. Upon adjudging that a party is the parent of a minor child, the court shall make provision for support and education of the child including the necessary medical expenses incident to the birth of the child. The court may order the support and education expenses to be paid by either or both parents for the minor child. Basically, if the court wanted to exclude minors, they could have or should have done so explicitly as the argument. The court argued, quote, this state's interest in requiring minor parents to support their children overrides the state's competing interest in protecting juveniles from improvident acts, even when such acts may include criminal activity on the part of the other parent. Considering the three persons directly involved, Shane, Colleen, and Melanie, the interests of Melanie are superior, as a matter of public policy, to those of either or both of her parents. This minor child, the only truly innocent party, is entitled to support from both her parents regardless of their ages, implying that the boy, at 13 years old, isn't an innocent victim. For men, protecting the interests of minors overrides every other thing. For women, giving women choice overrides everything. From this and all the other cases featured in this video, it is becoming increasingly clear that men are more of primary parents than women are, at least in terms of how family courts presents male and female responsibilities. But, family court also awards primary custody to women, while making sure men finance the court's decision. The Arkansas Supreme Court, in Ham v. Office of Child Support Enforcement, ruled that the minor was responsible for child support despite being 13 years old at the time that the child was conceived. Susan Atkinson was 15 and Scott Ham was 13 at the time when their child, Keegan, was conceived. Susan applied for child support through the State Office of Child Support Enforcement, with the office seeking reimbursement from Scott being Keegan's father. Scott's parents pursued a statutory rape criminal charge against Susan, who pled guilty to second-degree sexual abuse. The paternity action hearing resulted in Scott being named Keegan's father, but because of his age, he was not obligated to pay child support. Scott appealed, suggesting that the chancellor erred in naming him as the father and refused to apply the equitable doctrine of clean hands because he was a victim. The general rule in most jurisdictions is that the putative father who is below the age of consent to engage in intercourse, thus being a victim of sexual misconduct, is liable for supporting the child, with reference to multiple cases, including Jevning v. Sickos, Bennett v. Miller, Hermesman v. Sayer, Mercer County Department of Social Services v. Alf M., in re Paternity of JLH, and Skia and Beck v. Minor. All these cases were cited to counter Scott's citation of Reed v. Reed, where the court applied the clean hands principle but rejected the father's request to abate his child support obligations because he was in prison and was unable to earn. The appellate affirmed the trial court's ruling, arguing that child support obligations should not be modified because the means to pay child support was reduced or eliminated because of his criminal conduct. Effectively, Reed's child support payments accrued while he was still in prison and unable to work. In shutting down the Reed v. Reed argument, the court ruled that the child's best interests, and not the mother's or the father's, are considered when making the child support ruling. But when the unborn child's interests are protected over those of the mother in the name of equal protection under the law, then all hell breaks loose. The whole Reed v. Reed case and child support mounting even if the father is in prison was affirmed by Turner v. Rogers of 2011, which argued that inmates with paternity issues, especially those seeking child support modifications to reflect the time spent in prison as they're unable to earn, are entitled to the constitutional right to counsel. If the inmate cannot afford counsel and cannot defend themselves, then child support payments would continue to accumulate for the entirety of their prison time. Justice Corbin, who dissented, argued, quote, I take issue with the majority's reference to Scott as an underage consenting male victim, as our law provides that a person under the age of 14 is incapable of consenting to a sexual act. Our public policy, as fixed by the General Assembly, is manifest that victims younger than age 14 are beneath the age of consent and cannot be willing accomplices to sexual intercourse. I have grave doubts about the soundness of the decision to order Scott, a child himself, to financially support the infant, Keegan, born as a result of an illegal sexual encounter. To require a person under 14 to be responsible for a child born as the result of a sexual crime seems to thwart that public policy, which is clearly intended to protect young persons who are not capable of protecting themselves or making intelligent decisions about such matters. Although I do not disagree with the majority's recitation of case law from other jurisdictions or with the principle that the welfare of the infant child is of paramount consideration, I differ with the majority on the issue of who should support the child. Ordering Scott to support this child effectively punishes him for being the victim of a crime. To this end, I believe that this situation could better be handled like those in which the putative father is not known or is deceased. Otherwise, the message such a decision sends is that a victim of crime must pay for the criminal act of the perpetrator. For these reasons, I respectfully dissent. In Re: The Paternity of JLH in Wisconsin, the court heard from a clinical psychologist on the psychological effects of a sexual encounter of a 15-year-old victim, the victim's father, including how the victim was hospitalized on 5 different occasions in a year and his inability to keep a job at that young age. And the court ruled that the psychological and economic consequences of the male victim of sexual victimization were irrelevant to his fatherhood status and child support obligations. The court's implementation of gendered child support laws defeated the whole purpose of supposedly gender-neutral statutory rape laws. The Court of Appeals of Wisconsin in JLH said, the assumption underlying appellant's opposition to the motion for summary judgment is that a putative father in a paternity action has a defense if the sexual intercourse occurred without his consent. The amended civil complaint which his opposing affidavit incorporates alleges that the child born to LH was the result of non-consensual sexual assault in violation of Wisconsin statutes. The statutes define consent as meaning words or overt actions by a person who is competent to give informed consent, indicating a freely given agreement to have sexual intercourse or sexual contact. A person under 15 years of age is incapable of consent as a matter of law. The following persons are presumed incapable of consent, but the presumption may be rebutted by competent evidence: a person who is 15 to 17 years of age. The court further argued, quote, "We reject appellant's assertion that because he was 15 years old when he had intercourse with LH, he was incapable of consent. The assertion rests on the argument that Section 940.2254A of Wisconsin law created a rebuttable presumption to that effect. That statute pertains to the guilt of a criminal defendant, not to the civil rights or duties of the victim." The court goes on to state, if voluntary intercourse results in parenthood, then for purposes of child support, the parenthood is voluntary. Even if a 15-year-old boy's parenthood resulted from a sexual assault upon him within the meaning of the criminal law, the parenthood is voluntary for purposes of child support. But, sexual misconduct against a minor cannot be voluntary, as the father argued. The court looked at foreplay, hugging, kissing, and other acts as constituting consent, again, by a minor. Foreplay equals consent. Good people, foreplay equals consent. The court also rendered the consent provision meaningless when judging that statutory rape could result in voluntary parenthood. The Wisconsin court argued that sexual assault resulting in parenting does not absolve the victim of their civil responsibilities to support the resultant child. JLH relied on the Wisconsin statute, which states that minors under the age of 15 are unable to consent to sex, but the court argued that the statute is only relevant for criminal but not civil cases. The court stated, quote, "We reject appellant's argument that his paying child support to LH would permit her to benefit from her crime. Even assuming that LH criminally assaulted appellant, child support is paid to benefit the child, not the custodial parent. The custodial parent receives support payments in trust to be used for the child's welfare." Rejecting JLH as a victim was based on the argument that he did not register any complaints with his parents, thereby being a willing participant in the act. Absolutely interesting. In Re: The Parentage of J.S. case in Illinois, the court held that Illinois public policy did not protect the minor from parenting even though he was 15 years old when the child was conceived, because it was in the best interest of the child. When it gets to fathers, the child's rights trump the father's victimization. When it is the mother, her right to privacy trumps the rights of the unborn. Patriarchy, they call it. The appellate court maintained that public policy that protects a minor from his irresponsible acts does not trump the interest of the state interests to require the minor father to protect his own child. The court stated, quote, "We note that contrary to the respondent's position, Illinois public policy has never offered blanket protection to reckless minors. At the same time, Illinois public policy has recognized the blanket right of every child to the physical, mental, emotional, and monetary support of his or her parents. The public has an interest in protecting children from becoming wards of the state. Illinois public policy does not protect, quote, reckless minors, is what the court said. The court further states, the respondent initially argues that he should not be required to support his child, because he was a 15-year-old minor when the child was conceived. He contends that Illinois public policy protects minors from the consequences of their improvident conduct. In the instant case, we find that the public policy mandating parental support of children overrides any policy of protecting a minor from improvident acts. We therefore hold that the trial court properly found that the respondent was financially responsible for his child. In Bennett v. Miller, the Florida Court of Appeals argued, quote, a manifestation of public policy in favor of protecting children. The statute provides that the willingness or consent of a child is not a defense to the crime of sexual battery when the perpetrator is in a position of familial or custodial authority. The statute plainly pertains to the guilt of a person charged with sexual battery upon a child, while having nothing to do with the child support obligations of a biological parent. The statute does not create a defense for minor putative fathers in paternity actions. In Skierenbeck v. Minor, a 20-year-old female, married to another man at the time, had sexual relations with the plaintiff, who was a minor at the time and a child was conceived. The Colorado Supreme Court rejected any arguments against the man being responsible for child support on the claim that the child was an outcome of criminal conduct, specifically third-degree rape. The court argued, quote, certain it is that his assent to the illicit act does not exclude commission of the statutory crime, but it has nothing to do with assent as relating to progeny. His youth is basic to the crime, it is not a factor in the question of whether he is the father of Sherry Lynn. Imagine arguing that her youth is basic to the crime, and as such, the perpetrator should not be punished. The court further argued, quote, the putative father may be liable in bastardy proceedings for the support and maintenance of his child, even though he is a minor. If Skierenbeck is adjudged to be the father of Sherry Lynn after a proper hearing and upon sufficient evidence, he should support her under this fundamental doctrine. In Jevning v. Sickos, Jevning, a 20-year-old female, had a child resulting from sexual activity with 15-year-old Sickos. Sickos argued that he should not pay child support because he was a minor. The Minnesota Court of Appeals disagreed and argued, quote, statutory non-consent under some definitions of criminal sexual conduct does not translate to a holding that on the civil issue of child support, minors can never be held responsible for their children resulting from sexual conduct. Generally, minors are responsible for their actions, exceptions to that principle are rare. For instances, minors are generally accountable for their economic transactions, allowed to sue and can be sued, are accountable for acts of juvenile delinquency, and may be certified to be tried as adults, depending on the circumstances. Applying the equality principle of the Constitution, minor female victims of rape are responsible for their actions, with lack of or minimized responsibility being the exception and not the rule. Just recently, legislatures moved to define gender-neutral statutory prohibitions of certain criminal acts. As recent as the 1990s, statutory rape in California only covered female victims. While the prohibitions appear to be gender-neutral, their implementations are far from neutral because the role of statutory prohibitions has remained to prevent the consequences of teenage pregnancy, which of course only applies to female victims of statutory rape. The whole idea is not even to protect children from exploitation by adults as we have seen so far. Forget about the existence of birth control technology, the advancements in abortion, the exception for rape victims even in jurisdictions where abortion is illegal. Courts still behave like we live in 1950s where sexual activity automatically resulted in parenting. Forget about the fact that child support is mandatory in America like many other countries in the world, and that America imprisons fathers for up to 2 years for failing to pay child support, with 50,000 fathers being locked up in American prisons on any given day because of failure to pay child support. None of all this is enough to protect male victims of statutory rape from their perpetrators like pregnancy warrants the protection of female victims of statutory rape. Focusing on the possibility of pregnancy, which only applies to female victims, takes attention away from the criminal act and the criminal culpability of the perpetrator. Question. Since most girls clock puberty from age 8 to around 13, What if someone molested a 7-year-old girl? How about if an adult female is involved in sexual activity with a minor, in which case, the threat of pregnancy does not exist? While statutory rape prohibitions appear to be gender neutral, the contribution of statutory rape to teenage pregnancies has guided the almost exclusive focus on male adults and female minors. Forget about equal protection principles found on almost every constitution on the planet. Legislatures seek to protect girls from parenting at a young age, but young boys are not protected, at least equally, from the same. Studies have shown that boys and girls are similarly harmed by sexual victimization. However, the sexual socialization of boys and girls still plays even in the highest of courts in any land. Girls face stigma from victimization, while boys' stigma stems from the expectation that they should enjoy every sexual encounter. Boys might not express negative feelings after victimization as girls would, owing to the fact that boys are not raised to be expressive. Courts still rely on stereotypical presentations of male sexuality and failing to protect male victims while punishing male perpetrators at the same time. The courts are more accommodating of male sexuality when a man has been victimized, enforcing parental responsibility on them. But when the man is a perpetrator, that's where they draw the line and male sexuality has to be suppressed or punished. In every jurisdiction that fatherhood from statutory rape has been tried, the boy has been held accountable for being the victim of sexual victimization, thus pushing the government's stance on no exemptions for fatherhood. In Illinois, a child's mother or a person found to be the father of a child under this act is not relieved of support for the minor. The Illinois Reproductive Health Act says that women have the fundamental right to access abortion services, and that a fertilized egg, embryo, or fetus does not have independent rights. So, in Illinois, just like a number of other states, if not all of them, women have reproductive rights but men have reproductive responsibilities, as evidenced by In re the Parentage of J.S., where the appellate court focused on the public policies of the state to affirm a judgment against a minor male. The laws that protect young girls from unplanned parenthood do so under the full acknowledgement of how parenting at a young age could dramatically shape the girl's life, especially the opportunities it could limit them from accessing. But that's where it ends. The same laws do not acknowledge the dangers of being a father at a young age and the opportunities that a young man could potentially lose. Child support laws, in the name of protecting the best interest of the child, protect female perpetrators of statutory rape by further punishing the victim. Rejecting the arguments presented by male victims in these cases, state courts comfortably apply their public policies selectively by failing to protect male children from being victims of sex crimes and the resultant consequences. The outcry surrounding the overturning of Roe v. Wade is largely based on choice. A woman having the choice to determine her future and preserve the privacy of doing whatever she wants with her body. Rejecting the male victims of sexual victimization arguments of involuntary parenting, especially at the young age, implies that there are two sets of laws, ones that govern men and those that govern women. The courts punish boys for being victims of sexual misconduct and the public watches with no problem, until of course, we get to girls being punished for being victims of sexual misconduct by denying them the opportunity to opt out of parenting through the prohibition of abortion with no exceptions. Adult women in America have more rights than male underage children. Remember, the whole outcry surrounding female victims of rape being forced to carry their perpetrators' children is as loud as it is with abortion being illegal in half of the United States. Which means, female victims of sexual victimization still have the option of moving to another state to seek the termination of parenting. But for male victims, all courts agree that opting out of parenting is not an option, to the extent of calling male victims technical victims even though they engaged in consensual sex below the age of giving consent. Furthermore, it is becoming increasingly clear that for men, consent, even lack thereof, and voluntary parenthood are inextricably interconnected. A repetitive theme in this video has been voluntary and involuntary fathering of a child, and the courts held if an underage boy engaged in sexual activity, then it is not the law's job to protect him and the consequences of that. Interestingly, the whole voluntary and involuntary parenting in the context of men is just smokes and mirrors. After conception, men have no rights, at all, and there are no exceptions to that. Men don't even have to actually engage in actual penetrative intercourse with a woman to have a child support obligation hanging above their head. You see, when it comes to men, choice is not an option. No exceptions, no circumstances, no nothing. Too much for male privilege in the patriarchal society.